Alright, so I'm back to another part, and this is the Writ of HABEAS CORPUS, order to show cause. This is from the Unified United States Common Law Grand Jury, the Tribunal, the Superior Law of the Land, and I'm going to go ahead and just read through. There's going to be a lot of repeat of what I've already said in the petition that I first shared, and this is going to go further into the order now for these fictitious entities to show cause, but actually to come out from behind their corporate mask as men and women to come forward with a sworn affidavit under penalty of perjury, which they failed to do. So this is exposing this. This is a public notice that this has been filed, and that there has been an acquiescence to speak where there was a duty to, and there is going to be more added on to this video to show the default judgment and the order to cease and desist against my family, and that this has been ignored by all of those who have perpetuated these crimes against humanity against us and so many others out there. So this is meant to focus on the positive and what is going on around the world and what we can do to stop the human trafficking and to educate people as to what law actually is, what due process is, what a true court of record is, not what these public funded indoctrination system educational institutes are teaching young, gullible, ignorant people. So I was there myself, so I don't speak about this to tear anyone down. It's just what is going on, and so we need to move forward from here and to embrace knowledge and truth. So the Writ of Habeas Corpus, order to show cause, this was to Chief Judge Ann Aiken, assigned by the UUSCLG J, which is the Unified United States Common Law Grand Jury, the same case number, and this is against Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, an elective sheriff, Attorney Phil Wiseman, the court-appointed attorney, bar attorney for my little ones, and Attorney General Ellen Rosenblum. So it starts off with the same about the American Jurisprudence Constitutional Law 326. It says free justice and open courts, remedy for all injuries. In most of the state constitutions, there are provisions varying slightly in terms, which stipulate that justice shall be administered to all without delay or denial, without sale or prejudice, and that the court shall always be open to all alike. These provisions are based largely upon Magna Carta, Chapter 40, which provides, "We will sell no man. We will not deny to any man either justice or right." The chief purpose of the Magna Carta provision was to prohibit the king from selling justice by imposing fees on litigants through his courts, and to deal a death blow to the attendant, venal and disgraceful of a corrupt judiciary in demanding oppressive gratitudes for giving or withholding decisions in pending causes. It has been appropriately said that in a free government, the doors of litigations are already wide open and must constantly remain so. The extent of the constitutional provision has been regarded as broader than the original confines of the Magna Carta, and each constitutional provision has been held to prohibit the selling of justice, not merely by magistrates, but by the state itself. So sorry, I'm kind of fumbling over my words. It's so small and it's really hard to see. But it says to Judge Partridge, to Judge Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum. Please take notice that on January 15, 2016, a petition for writ of habeas corpus was filed on the above entitled Court. Emergency hearing. Papers due January 22nd, 2016. Respondents are to mail response to P.O. Box 59 in New York. And then it has Judge Lindsay Partridge, Judge Thomas Hart, Marion County Sheriff, here Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum, and their addresses again. And it says, it appearing that the applicant is entitled thereto, Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum are directed in accordance with 28 U.S.C. 2243 to forthwith release the party herein named as petitioner from custody. If petitioner is not forthwith released from custody, then within 3 calendar days after service of this writ, Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, and Attorney Phil Wiseman, and Attorney General Ellen Rosenblum shall make a return certifying the true nature and cause of the detention, and shall show cause why the writ should not be granted, mailing the same to P.O. Box 59 in New York, no later than 5 p.m. on the last day of the above stated 3 days period allowed for response. Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum shall make a return certifying the true nature and cause of the detention, and shall show cause why the writ shall not be granted, mailing to the P.O. Box 59, New York, no later than 5 p.m. on the last day of the above stated 3-day period, allowing for a response. Judge Lindsay Partridge, Judge Thomas Hart, County Sheriff Jason Meyers, Attorney Phil Wiseman, and Attorney General Ellen Rosenblum must each state in his return plainly and unequivocally, 1, whether or not he has the party herein named as petitioner in his custody or under his power or restraint. 2, if he has the petitioner in his custody or power or under his restraint, he must state the authority and cause of such imprisonment or restraint. 3, if the petitioner is detained by virtue of any sworn writ, warrant, or other written authority, a sworn copy thereof must be annexed to the return, and the original produced and exhibited to the court of magistrate on the hearing of such return. All unsworn documentary evidence will be refused for cause as hearsay. 4, if the respondent upon whom the writ is served had the petitioner in his power or custody or under his restraint at any time prior or subsequent to the date of this writ of habeas corpus, but has transferred such custody or restraint to another, the return must state particularly to whom, at what time and place, for what cause, and by what authority such transfer took place. 5, the return must be signed and sworn by the respondent, making the same, and except when such respondent is a sworn public officer and makes such return in his official capacity, it must be verified by his oath. 6, the applicant or the petitioner detained may under oath deny any of the facts set forth in the return or allege any other material facts. 7, the return and all suggestions made against it may be amended by leaving of court before or after being filed. By leave of court before or after being filed. 8, when the writ or order is returned, a day shall be set for a hearing that is not more than 3 days after the return, unless for good cause additional time is allowed. 9, because of the petition presents issues of facts as well as issues of law, if petitioner is constrained by actual physical force, then the jailer is required to produce at the hearing the body of the petitioner detained. 10, are there any affidavits from a witness? 11, are there any affidavits from an injured party? 12, Answer all charges in petitioner's petition. 13. Rebut petitioner's affidavit. The court is to notify this body, the Unified United States Common Law Grand Jury, by mail, and Sherry, my family, by mail and phone, to inform them as to the time and date of the hearing to be held at the above said courthouse. At the hearing, Chief Judge Ann Aiken shall summarily hear and determine the facts, shall dispose of the matter as law and justice require under American jurisprudence, aka the rules of common law, not chancery, and shall mail by United States Post Office a certified copy of decision immediately within 24 hours to the Unified United States Common Law Grand Jury for judicial review. If respondents default and therefore schedule no hearing, then Chief Judge Ann Aiken shall confirm release of petitioner and abatement and inform the Unified United States Common Law Grand Jury of the same by mail. The Court, January 15, 2016. Grand Jury Administrator.